we recently lost my father-in-law, and about 5 or 6 years ago, he sat my husband and my husband's brother down, and with a solicitor, and they wrote the will. They became the executors. He was really clear about who was to get what, and it was great. So when it happened last month, it just made life really easy for us to. He'd prepaid his funeral. He'd even written his eulogy. So it was, it just made life, and it made me think now, actually, I need to do something similar to make life easier for my kids.
Yeah, I mean, I can help with prepaid funerals, and I'll often do that for elderly folk who've gone into a home and things like that, because it makes life so much easier.
Yeah. What he didn't do was, so he's left his house to my husband and his brother. There is a sister who's not getting very much for various reasons, but that's all been made clear. But what he didn't do was put the house in the boys' names. So the house is now gone into probate, and we're expecting it still to take about 6 months.
Yeah,
but we could do anything.
Although that said, it's better not to do that. So if you put it into your husband's name, your husband would then potentially have a capital gains tax liability. So it's and it doesn't get round inheritance tax. So it's sort of it's not a very good win situation. Yeah. So everybody who's got a reasonable size estate goes through probate. It depends is how long it takes. It can take an enormous amount of time, and I had one recently that took a fortnight. Mm-hmm. It took us a while to get the stuff collected in, because it always does, because you're reliant on banks. But he'd also left his estate very tidy because he hadn't got loads of banks. He'd streamlined everything, and then from there, that had all gone in.
Okay, so if he had put the house in the boys' names, then we would have been liable for capital gains. So does that mean we won't have to pay capital gains if we sell the house?
Yes,
because it's part of the estate.
Yes, yeah, because it will. You may not have paid inheritance tax, but it's the allowance is nil rated, so it's considered to be paid, if you like. So yes, you won't. Unless there's a big blip, the estate sometimes gets to pay capital gains tax. Mm-hmm. Isn't that lovely? But that's, they want to get it everywhere, don't they? So
yeah. So in terms of protecting, thinking about protecting my generation, the next generation for us, we shouldn't put our property in our kids' names then. No. Okay, that's interesting.
I'd never recommend that. Never. It's not something I think makes any sense at all. It doesn't save you from inheritance tax. It might save you from getting a grant of probate, but because it's a life, because it's a life interest, you still have to declare it as probate, as an interest in inheritance tax. So it doesn't get around that. It doesn't. It makes it just as difficult. And somebody else having a house may potentially then have to pay capital gains tax. Mm-hmm. So I wouldn't. And then all the other issues, like if your children go bankrupt, it becomes matrimonial property. There are all those issues that you've got your children on the house you live in. They, God forbid, get brain damaged and put under the court protection. It's or they die. All those things are not. But yeah, I'm not. I mean, some people say put it in a trust, put the house in a trust so that everybody. I'm not a fan of that. I think it costs a lot of money. And
Joy, because that was one of the questions I was going to ask. Can you kind of elaborate on what exactly that means to put property into or assets into trust?
The property, if you haven't, don't have a mortgage on it, you can put the property into a trust, which is drawn up by It's not something I do. I would pass it to a colleague because he's much better than me at that sort of trust work, he's more experienced, shall I say. But I always try and stop people going against that because you lose control of your property. And if you need to get some money, maybe to do an equity release, you won't be able to do it. And it costs a lot of money. We're talking sort of 30,000, 40,000 to put it in.
Right.
And so you've got to be saving a lot of inheritance tax before you do that, to consider doing it. And you will get away with inheritance tax in that thing, in that case, but not, when you think the nil rate bands all added together are £1 million if you've been married, 500 if you haven't. If you're not going to pay tax, then doing all that stuff just to avoid a grant of probate is probably not, is a bit false economy, really.
Okay. And following on from that, because I'm aware of time, we've got lots of questions to get through. So we never want to avoid, but can we be inheritance tax efficient?
Yeah, well, you can't avoid, you know what? Yes, we can, but not in death. So inheritance tax is avoided in life, not in death. There's one of my favourite quotes was by, I think it was Roy Jenkins, when he was the Labour Chancellor of the Exchequer, and he introduced inheritance tax from the death duties and the prolist. And he said inheritance tax is a voluntary levy paid by people who distrust their family more than they dislike the inland revenue.
Wow.
So, yes, but you need to do it in life. And using, as property investors, using things like LLPs and smart companies and all that sort of stuff will limit your liability. But if I was to say, I'd say you ought to pay a little bit because it keeps them off your back. But if you're if you can keep your estate under the million and you've been married, then do so. Because then you won't have anything to pay. And that's ways of avoiding owning stuff in life, like having income only shares in your limited company and no capital and growth shares and things like that.
Fantastic. Well, look, I know I've got loads more questions, but I'm just aware that we've got quite a long list of questions. So I want to get those answered, otherwise we'll never get through them. But Robin, I'm trying to invite you up on stage. If you wanted to come up and ask your question, but I'll get going. So Robin said, interesting discussion. I'm 26 and wills are something that I've been heavily looking into. I'm not sure where to start. I do have life insurance in place, but no clear plan of action. Should the Reaper knock? Gosh, that's very good. And he says, I have a long-term partner, property and children, but not yet married. Our property ownership is under tenants in common rather than owned jointly. Any thoughts on that for Robin?
Yeah. First thing I would consider is what is the size of your estate? If you're not married, you can't make use of the wonderful tool of spousal exemption. So if you die and your estate is taxable, so if you die and you leave your house to your partner, which would be the expectation, you would have to pay income tax on everything over 325,000. Inheritance tax, not income tax, on everything over 325,000, and that will need to be paid immediately. So if you've got a fairly sizable property portfolio, you're going to be selling some of it to pay the tax off, but you can't pay the tax off till you can get the grant of probate. And then, of course, in that situation, there are people limited. Reading between the lines on that one, I would imagine your partner can get the grant of probate, because if children you have are under 18, she is the guardian of them. So she as the guardian of the children under 18, but she will need to appoint another trustee. I am about to come up, I can't believe how quick it's gone, but I'm about to come up to the end of my period of being a trustee with my niece. Because her partner died without having a lasting, without having a will, and she needed to appoint somebody else as trustee. So that we did that, but you're stuck with it for a long time.
So the only way to get around that is to actually marry your partner.
Yeah.
Yeah.
And I used to have people saying, "Oh, I ain't getting married. And I've had 4 or 5 get married in the last 3 or 4 years, because you add up the amount of tax due, because that's one of the things we would look at when we were talking, is what the value of your assets are and what your insurance is, and work out roughly how much the tax payable would be today. As I usually say, yesterday when you die, because I don't killed you off then, you've been already dead. But you then work out how much tax you have to pay, and that has to be paid on the first death. If you're not married. If you are married, you can use spousal exemptions, and then you leave your nil rate bands to your partner. So they get your 500,000 if you're leaving your property. But a lot of us property investors don't actually live in the houses we own, for varying reasons. We're on an option or whatever, because we wanted somewhere bigger, or we've decided to rent. In that case, you don't get the extra 175,000 residential nil rate band, because you have to live in the house that you're leaving to the person to qualify for it, and you also have to leave it to a direct descendant. So if you're not leaving it to your spouse, if you're leaving it to your partner, they aren't your direct descendant. So you're not entitled to use it, or you're not living in it. So you haven't got that allowance anyway. I think that might change.
So that's a very interesting one, and in fact, I have questioned a young gentleman, in fact, who we both know, Joy. I'm not going to mention any names, and he's very adamant about not getting married, even though there was a lot of property there. And his view is that there's a 50-50 chance of divorce, no matter how one goes into it. So, is there a benefit cost in compared to cost out? Because is it kind of cost in the fact of, you've got to be sure that you're going to be half the ones that stay married, because of the cost out could be more than that? Or
I'm interested into why people think that they're not going to get away with a cost. So if they've got children together, it could lose stuff anyway, because it changes how the courts view the maintenance arrangement. So he's not going to be able to walk away with all his property portfolio, because they could give the house to his partner. So you might just as well be married. In fact, I think it puts you on a better and an even ground.
Interesting. Well,
yeah, so my son and his girlfriend, they have a little boy together, and they're not interested in getting married yet, but I can now see that there might be a conversation to be had about protecting. They're about to buy a house together. At the moment, they live in the house that my son bought. So they might ought to think about the benefits of getting married.
Yeah, because it's all very well saying, yeah, all right, it's annoying, you might lose, but I've had people who've they've got interests under trust. A former secretary of mine got half of her partner's house under a trust. She wasn't on the deeds, because she'd done things and done work and had really. So she took him to court because he kicked her out.
Mm-hmm.
I gave her a deposit to buy her new house.